Hello, hello. Good morning.
Oh, hello.
Welcome, everybody. Thank you for bearing with us as we have a few minutes late, but very happy to see a lot of people in the room and hopefully online as well to follow this session with us this morning, which is going to look at the international dimensions of enforcement. So there's a lot for us to discuss, and we know we're standing between you and the lunch break, so we'll try to make this one as interesting as possible for you. And I'm very fortunate to have an amazing panel with whom to discuss what the GDPR can learn from the world. So I don't think my panelists need any introduction, but I'll just still mention names and affiliations so that we can go straight into the conversation. So starting far left, we have Bruno Gencarelli from the European Commission, Head of International Data Flows and Protection at DG Justice. Next to Bruno, we have Jane Horvat, Chief Privacy Officer at Apple. We have, I'm sorry, I'm struggling with my microphone. I'll do Miriam first as well. Miriam Wimmer, Director for the Brazilian Data Protection Authority, ANPD. James Dipple-Johnstone, Chief Regulatory Officer and Deputy Commissioner at the ICO. And last but not least, Brent Homan, Deputy Commissioner at the Office of Privacy Commissioner of Canada. So thank you very much, all of you, for joining us today. Obviously, we've heard a lot already in the general session about the general themes of the discussions today, but I want to maybe start off with laying some terminology, because we hear about compliance and effective protections, and those are typically two different concepts, right? So I'm curious to see how you all define those two concepts. And perhaps when we look at adding the enforcement piece into that equation, is there anything else that we need to consider? Are there other factors, like risk-based approach, for instance, and other elements that to you are really foundational to working through effective enforcement in this respect? So Miriam, perhaps let me turn to you first, if you can give us a sense of how do you define those different concepts?
Fine. Do you hear me? Is everything working? Hello? Hello? Okay, now I think it's working. So thank you very much, Isabelle, and I'd like to say that I'm delighted to take part in this panel, speaking on behalf of a very young DPA created last November 2020, so we are not yet 2 years old, and I think it's very challenging to speak about enforcement, compliance, and accountability, which are three terms that do not have a precise translation into Portuguese. So in Brazil, we tend to speak a lot about the responsibility of public organizations, responsibilities or competencies of making sure that fundamental rights are observed and protected. On the other hand, we speak about the responsibilities of private organizations in taking the necessary steps in order to ensure that they comply with the legislation. And I think that when we look at these complex terms and these complex relationships between public organizations, private organizations, also civil society, I think it's important to take into account that enforcement is in fact a spectrum of different tools that can be applied in order to promote compliance. So I think it's very common for us to speak about enforcement thinking only about administrative fines or very strict interventionist measures in order to promote compliance, but especially in Brazil, which is a country that has only recently approved the General Data Protection Law, that does not yet have a strong culture of personal data protection, that has over 230 million inhabitants, over 20 million companies, and a very small DPA. It's important to look at other tools and other regulatory strategies in order to promote the observance of the law and the respect for fundamental rights. So what I've often heard is that personal data protection is usually over-regulated and under-enforced, and I think perhaps our challenge is to define enforcement so as to make it effective in order to promote compliance.
Thank you. So maybe I'm going to turn to James and Brent to add perhaps to that or comment. Brent, you want to get started?
I guess the way that I see it, enforcement is activity. Compliance is the result if the enforcement is done correctly, and protection is the benefit to consumers and society. So when you think about enforcement, you don't have to investigate something just for the sake of investigating it, and finding a fault is not success. What is more important is that what arises from that fault and what arises from the conclusions of the investigation, and to ensure that whatever the recommendations, whatever the commitments that are made, they're enduring, which makes it important to ensure that those commitments, those recommendations are such that a business can see the value in complying with it, not just because the laws exist, but because it makes a business sense advantage into it. I'll tell you that for speaking from Canada, we're in a position that is unlike others in Europe in terms of we don't have any enforcement powers, order making and or findings at the federal level. We're hoping that that changes, and we're expecting that to change very soon. In fact, there's an order in Parliament that's going to be introduced, we understand today, to change that effect. But that means that we've had to kind of exercise and use muscle memory in different ways in terms of ensuring that we carry out activities related to public interest disclosures and appeal to the, really truly appeal to the desires of the business in order to comply and why it makes good long-term sense. And finally, I think what I'd like to say on this is that what's really key is accountability. And accountability for organizations, it's a dynamic responsibility rather than a static one. Many, many times we've seen organizations that have policies and procedures and safeguards that look great on paper, but that they fall down when you look at them sideways. And to the extent that it's really important, what we see is the foundation of accountability is that organizations take the time to make sure that they're mindful of these processes, they follow them, they monitor them, and most importantly, in the area of privacy, which is always technologically evolving, that they keep an eye on the risks that are coming down the road and adjust where necessary.
Mm-hmm. So it's a process, it's a journey, as we say, but it's interesting to see how you mentioned accountability. You've also mentioned this idea of culture of privacy, which was very much a theme of the general session as well. So maybe we can come back to that afterwards. Do you have an idea, really? Perspective on the ICO.
Is this working? Is it? Yeah. Okay. Good. Yeah, I mean, we have a very similar approach. Enforcement plus is a continuity. It's a continuum. And I suppose the best analogy I can draw upon is if you look at speeding and police enforcement of speeding, it's not just about the fines or taking people's driving licenses away from them. It's about putting up signs to say what the speed limit is. It's about driver speed awareness courses. It's about learning to drive, and it's about providing advice and guidance, when you've been stopped on the M6 on your way home and you're going too fast, naming no names. But we view our enforcement as all of those things. So it's about producing commissioner opinions, producing many hundreds of thousands of recommendations for industry across the country, but in those cases where we need to, also taking action at the sharper end. And again, focusing not just on a tick box exercise, but looking at what the organisation is doing, what its accountability arrangements are, and how it's demonstrating at board level those accountability arrangements.
Thank you. Bruno, from the Commission's perspective.
First, thanks for having me here, also because the title of the panel is what to learn from others, and here essentially to learn and should be silent, but I can tell you that I agree with everything that has been said. I see this very much as two interrelated concepts, almost two sides of the same coin. Probably. Does it work better? Yeah, I think so. So I see this as two interrelated concepts, almost two sides of the same coin. Effective compliance leads to effective leads to effective protection, if I may say, and that's an idea, a concept which I think is a problem.
Again. Mine's on.
I'll try again. Bon. So what I was trying to say is that effective compliance leads to effective protection. That's a concept which is actually at the basis of many elements of the GDPR, as of many other privacy laws, from accountability to privacy by design or by default. The question is, Rather, how do you get the two sides of that equation right? And that, as all my co-panelists have said, involves a wide range, a spectrum, as Miriam said, of measures, a mix of different elements, of different measures, from awareness raising to guidance, to measures that are put in place to incentivize compliance. And of course, also dissuasive elements, and that's where enforcement play its role. And even there, enforcement, and that goes a bit to your second question, the role that other factors have to play in choosing the right enforcement tool, from warning to injunctive relief or corrective measures to fines. Even in the way you calculate fines, there a wide range of factors can enter into account, including the impact of the violation of the measures of the measure you have found as in breach of the relevant rules. And that's where, for instance, harm can play a role.
Thank you. And maybe Jane, from a private sector perspective as well, and I want to add, perhaps, as we hear about accountability guidelines and such, I mean, being in the shoes of an official in a company who's on the receiving end of all of that, maybe
Sure.
adding your perspective there.
I don't think my mic is live now. Now it is. Sure, from a corporate standpoint, or from Apple's standpoint, I think the three are all very much interrelated. Number one, compliance. We operate across the world, so we are subject to laws across the world. When GDPR was being drafted, we were supportive of GDPR because we thought that our privacy protections that we had already put in place were GDPR compliant. And we've been advocating for strong privacy laws, particularly in the US. Very hopeful that maybe there is that window to get that across the line. But so compliance, we have a compliance team, and the compliance team is very much looking at the laws and making sure that we're complying with the laws. The privacy protection that we do internally is much more about privacy by design. So we look at that and we embed privacy lawyers, privacy engineers in each and every product, very much laser focused on the individual. And so some of the things that we do and impose, we look at it from four main principles. They're all derived from the world's privacy laws, the Fair Information Practice Principles. Data minimization. Minimize the amount of personal data that you collect. Doesn't mean don't collect data. There are a lot of interesting techniques that you can do, random numbers, sampling, to actually minimize the personal data. The next one, process as much information on device as possible. Because if you're not the controller of the data, then you can avoid the third prong that we talked about, which is enforcement. We try to collect less personal data so we can avoid enforcement. And then the third principle, transparency and choice. No surprises. Make sure your customers know what's going on with their data and give them relevant choices. And then finally, you're not going to have privacy without adequate security.
Thank you very much. I want to pick up on a couple of things that were mentioned. Again, talking about the culture of enforcement, and as well looking at you, Miriam, as well from a perspective of a fairly young authority as well. How much the levels of maturity in the market do influence the way supervisory authorities are going to look at how to approach those issues, and how do you actually build that dialogue that we've heard so much about during the general session as well on that? And maybe with that, do you see, since the title of the session is what can the GDPR learn from the world, are there good examples out there of specific influence or enforcement setup that are particularly influential, that work well? James, I'm going to pick on you from a UK perspective. anything the ICO is looking to do slightly differently or revisit? And Jane, I'll come back to you afterwards as well in terms of some of the 4 principles that you've mentioned and the evolution of technology and how that plays into adapting those principles. But maybe on.
Thank you. Yeah. Hopefully this is a bit better than the last mic. Yeah. Okay, good. So our view is that there isn't a one-size-fits-all approach, and we've benefited hugely from learning from our colleagues around the world, both when we were around the EDPB table with colleagues in the EU, but also more broadly. Our approach is very much to engage and to try and encourage and support. And so we've developed things like the Sandbox tool and our advice services, and use things like commissioners' opinions to set expectations, and have then been following that up with sweeps to gauge compliance within organizations on a risk-based approach. And even through that approach, what we are looking at is the potential for individual harm from each individual case use study. So within a particular sector, we might engage with many organizations. We might carry out on-site inspections of a smaller subset, which then might lead to recommendations to a smaller subset of those organizations, and that might be followed by issuing enforcement notices or administrative penalties for a much smaller pool of those organizations who have shown themselves unable to do the privacy by design and the compliance piece to our satisfaction, and demonstrate their accountability, not just to put things right in the first place, but then to take feedback from the regulator. So that's very much our approach, and hopefully that's helpful. But we've based that approach on the learning we've had from engaging with many counterparts all around the world, and examples like the International Enforcement Working Group of the GPA and its work on VTC platforms is a good example of that kind of approach at the beginning of the pandemic.
Thank you. And you've actually mentioned a couple of points that were leading to a follow-up question for you, Jane, in terms of how much the business model of an organization, its ability to actually put resources behind those efforts as well. Obviously, Apple is not your typical SME, but I'm curious about how Apple sees those challenges internally and how maybe you're addressing them to sort of help build that supply chain and that ecosystem as well, to reinforce to your point.
So I think that the way we look at privacy is it's part of product development. So privacy needs to be considered from the ground up. It's as important as a screw or the screen on the phone. It needs to be built into the product and integrated in, and in that way you're building something that is compliant and accountable to the privacy laws and privacy by design. And I think the other important element that we as a company think when we're working with regulators is when we have a new technology that we've designed, it's really helpful to reach out and brief regulators. One great example from the pandemic was we developed, along with Google, a joint technology called exposure notifications. It was a privacy-focused way to notify you if you could be potentially exposed to COVID. You're sitting on a park bench, someone next to you reports an exposure. It all takes place on your phone. And it was a new technology. And so one of the parts of our product design was actually to reach out to regulators and brief regulators on it. So there was a fundamental understanding of the underlying technology to get ahead of things. And I think that ongoing dialogue with the regulatory, particularly as a company that operates worldwide, it is really important as you're developing new technologies to keep that dialogue open.
So one question I would have on to follow up on that, and I welcome everybody's views on that, is that this sort of supposes that there's a certain level of comfort in an organization going to a regulator to ask those questions. It also implies that there's a certain scalability to that approach as well from both sides, right? That authorities have the bandwidth to do that. You've mentioned sandboxes. Is that a good setup to have those conditions in place? Are there other elements that we can think of to, again, create those conditions for a genuine dialogue and allowing for that scalability as well.
Yeah, I think going back to the idea of international collaboration, and James had mentioned the International Enforcement Working Group of the Global Privacy Assembly. And it is a platform that allows for collaboration for enforcement on a continuum, from less formal to more formal, supporting joint investigations, or being the impetus for joint investigations. Now, a unique opportunity that was more a less formal initiative was during the pandemic, this engagement flowing from a closed enforcement session of this working group, looking at the risk of video conference technology, and seeing that in January of 2020, people didn't know who Zoom was. By March, everyone did. And it was so important and became so prevalent that everyone's minds turned to the privacy security aspects of it. Now, this was not a situation that was conducive to an investigation that would take a long period of time that individuals and consumers would not benefit from. So what happened? There was an innovation with collaboration, benefiting from a group that engaged with the top 5 VCT producers and operators in the world in order to identify the expectations of the privacy community, to engage with them, discuss and share the best practices that had happened within that group. And importantly, and I think why it worked, was that those discussions were authentic and unguarded. It wasn't an investigation, it was a less formal initiative, and it was certainly wrapped up in less time and with greater impact, I'd say, than if this was approached individually.
Thank you. Okay, thank you. Miriam, you'd mentioned when we were preparing the panel that Brazil was looking at a step-by-step approach as well. And I'm curious whether what was discussed now around sort of sandboxing and this idea of creating a safe space to speak to experience and to talk through those privacy challenges, is that part of the approach that you're thinking of? And can you describe that a little bit more for us?
Of course. Can you hear me? Yeah. So I think maybe your previous question on how the approaches should vary according to the maturity of the market is very much to the point, and especially when you look at Brazil, a country where people are still beginning to figure out what personal data protection means. In fact, it's very necessary for us to create these spaces where dialogue can happen in an unguarded manner, as was mentioned previously, where organizations can come to us and say, look, we're planning to launch this new service. Of course, as a DPA, we can't always say, go ahead, that looks fine, but it's important for us to be aware of what's going on. So our approach in Brazil is what we have been calling a responsive approach, an approach to responsive regulation, which is often placed in contrast with a more command and control approach. And of course, we've also been seeking to learn from the experience of other countries and other regulated sectors. And I can bring perhaps as an interesting example, the telecom sector, where I used to work previously, where in Brazil, over 20 years, under command and control approach, our regulatory agency applied a huge number of fines that were many times not even paid, were taken to courts, and we didn't see any direct relationship between the number of fines applied and the effective change in the behavior of the regulated companies. So what we have been working at the ANPD to do is to build this strategy based on the idea of a pyramid, where at the base of the pyramid we have less interventionist, less coercive strategies that should be tried first. So the idea of sitting down at a table and explaining what people are doing wrong and what they should correct. And in fact, our regulation on monitoring, it foresees 4 different stages. So first of all, monitoring the market and then receiving complaints and treating them in an aggregate manner to figure out what the main problems are, what we should tackle first in a strategic manner, then issuing guidance. And I very much appreciated the example of speeding and speed bumps and signs and so on. So we feel there's a role also of education and guiding people on what they should be doing. then prevention, and then we would typically be issuing a deadline for organizations to correct their conduct. And finally, repression, and then we have a number of different sanctions we can apply, which includes fines, warnings, suspension of data processing activities, and so on. So I think the main idea here is that organizations are able to respond to different incentives, and perhaps we should create an environment where organizations have the incentive to seek cooperation at an earlier stage rather than simply postponing the application of a fine, which may take several years. So in a nutshell, that's what we've been working on. And I think also another important part of this is cooperation between different governmental agencies, such as consumer protection authorities, antitrust authorities, and also public prosecutors.
Thank you. Yeah, we'll come back to that collaboration aspect later on in the panel, but I want to turn to Bruno now, since the idea was, as you said earlier on, to hear what is done in other jurisdictions. So from what was discussed up until now in the panel, is there anything sort of concrete existing tools out there that you think might be good additions to the way enforcement is looked at in Europe? Any lessons to be learned, and perhaps looking at the international aspect as well in the GPA as well, which was an interesting element.
So thank you for that question, and it raises several sub-questions. I'll try to be brief. First, whether this has always been about learning from others. We have learned from others, we continue to learn from others. Even when we drafted the GDPR, we proposed the GDPR, we adopted the GDPR, many of the ideas, many of the new concepts of the GDPR were coming from other systems, from the very principle of accountability to data breach notification, for instance, which didn't exist in Europe. And that continues because nothing is static. I was thinking about Brazil, because Brazil has a very interesting concept in terms of interaction with stakeholders, business community, government, social, civil society. They have, I think it's called like this, and translated in English, a national council, that which is a permanent body where you have representatives of those different stakeholders, and that advises the Data Protection Authority in a number of regulatory choices, guidance. Miriam, you can tell us more about this. Well, that's a very interesting example. Doesn't affect, of course, the independence. Those are advices, but that gives a sort of a continuous, I think, sort of reality check and feedback. And I think that's part of the evolution of also our system. I remember that when we started with all this in the EDPB, just after the entry into application of the GDPR, the UK was still here, the big question was, how do we engage with stakeholders? Mm-hmm. Do we systematically consult stakeholders? As the Commission, and probably, James, you will remember, we pushed very much for that. And that for some, and I understand, I mean, it is, for some of the members was quite a novelty. You're taking, of course, when you're engaging, you're taking a certain risk, also because what you're proposing might be criticized or some new issues might be raised. Now, a consultation of stakeholders by the EDPB has become the general rule. And maybe from something that was used to be at the beginning a rather formal or formalistic process, I can tell you now that each time there are in-depth discussions about the feedback they receive on, for instance, proposed guidance. So that's, I think, an element it's part of that, I think, dynamic evolution and where we see interesting examples from abroad. And then last but certainly not least, what you asked about cooperation and new forms of cooperation. First, within the EU, I think everybody will agree here that privacy probably has never been as central as today. But at the same time, something I always believe, the GDPR, and it's clear that the GDPR is not the law of everything, and DPAs are not supposed to do everything. And I think that the adoption of a number of recent pieces of digital legislation, such as the Digital Market Act, the Digital Service Act, showed that actually will help in a certain sense by showing that there are different pieces of rules, and they are not all about data protection, there are other aspects, but it will require more cooperation between data protection and other regulators, and we don't have the time now to go into the details, but each of these acts provides for those cooperation, consultation mechanisms. We also see, and this is something on which, for instance, as the Commission, we are very much working and supporting, that there should be a better and a more frequent dialogue between consumer authorities and data protection authorities, also something that I think has improved. And then at international level, yes, there are tools. Some have been mentioned, GPA, GPEN, but I must say that when we think that most regulators around the world are looking at the same things, they're looking at the same behavior, the same actors, that they're looking at practices and behavior that might simultaneously affect hundreds, thousands, millions of consumers at the same time in many jurisdictions, cooperation between data protection regulator is underdeveloped compared to other regulatory areas. Competition, cooperation between financial supervisors. There's no real instruments in terms of investigatory assistance, sharing information in the context of individual investigation, which makes difference when you are an enforcer. Comparing your notes, comparing your assessment. What, for instance, DG Competition does with the FTC, its Japanese, its Brazilian colleagues. So I think that's something that needs to be a step up, and we have the tools for that. Article 50 of the GDPR, for instance, and we intend in the coming months and years to conclude such enforcement cooperation agreement with our main partners. So it was a bit of a long answer, but I was trying to cover the many issues you referred to.
Thank you. Brent, did you want to comment on that?
Yeah, well, I can just say on that issue on cooperation in Canada, that has been the adopted philosophy that we've taken, and we've really embraced the idea of enforcement collaboration. And let me talk about the benefits before I dive into and reverse it and talk about how we've done it. Like the benefits, if done well, if done properly, you expand your capacity to take action, and then you amplify the impact of those actions through your collective voices. And so we have engaged in enforcement cooperation and joint investigations where you don't necessarily have to share, most investigations, you don't have to share any personal information because it's all about the conduct. And we benefited from, I guess, the first privacy joint investigation we carried out with the Dutch on WhatsApp. And most recently, on the domestic level, collaborating with our enforcement partners in Canada on a matter relating to Tim Hortons, which is a coffee shop in Canada, and geolocation, and the question of whether your coffee shop needs to know where you are 24 hours a day in order to sell you coffee and donuts. And we said no, apparently. So basically, that's like at the enforcement level. But you mentioned GPEN, like the less formal enforcement results, like the sweep, the global privacy sweep that allows a organization or a regulator, whether you're a size of 300 or a size of 3, you can equally participate and benefit from those from those outcomes. And I think as well talked about the IEWG, but enforcement cooperation and collaboration on joint investigations and then less formal aspects, I think, is the key, especially since we're all dealing with the common digital risks. And in terms of cooperation, and I know what the ICO has done. Look at Clearview. There's been like a series of joint investigations around the world that were like dominoes tipping over and leading to what you in Australia have been doing, James.
Yeah, and I sort of very much agree in terms of the direction of travel there. I mean, we've found that very helpful to be able to work with colleagues in that way. And echo the point, it's more about understanding and the tactics and the development rather than necessarily personal information transfer, because that's often what, and the session this morning is about how how many DPAs have resource challenges. every time we're all duplicating the same technical analyses or trying to get the same bit of information and put it into our respective systems, that is just duplication. And I'm sure from the company perspective, being on the receiving end of 27 different requests, all slightly different in terms of what they want, it probably isn't very helpful. And it generates burden on both sides. So I think that's a key direction of travel. And we're increasingly doing that in the ISO, not just internationally, but also domestically with some of the other regulators. So we've obviously set up the DRCF, the Digital Regulators Coordination Forum, with our colleagues at Ofcom and the CMA and the Financial Conduct Authority. But also we are increasingly working with counterparts, for example, trading standards, looking at predatory marketing to vulnerable people, with our trading standards and law enforcement colleagues on data-enabled scams. I think for DPAs, maybe over the coming years, collaboration and cooperation is going to be the name of the game in terms of having impact. There's perhaps still a challenge around remedy and how you reflect remedy in different jurisdictions, but certainly I'd agree with colleagues in terms of the direction of travel.
Yes, and I'll just make a plug for the audience to start preparing your questions because I'm going to open it up very soon.
Will be very short. I mean, you've explained very much what are the benefits of enforcement cooperation for DPAs in terms of need of economies of scale almost, and in terms of expanding the impact of the investigation. I think there are clear benefits for data subjects if in terms of meaning certain behaviors being investigated and sanctioned when necessary in different jurisdictions. So in terms of sort of continuity of protection also from that point of view. But I must say there are also clear benefits for stakeholders and for businesses. Mm-hmm. Now, if similar conducts and similar behaviors are investigated at the same time in a collaborative way, it means also that similar and sometimes identical concept will be interpreted in a more convergent way. So for businesses that have to navigate between different jurisdictions, and that it's not only true in terms of cooperation on enforcement, but also cooperation, for instance, on certain guidance, on similar documents. So indeed, I think that this is we all need to push for that chapter to be really opened and maybe in a more committed way than it has been the case in the past.
Thank you. Jane, would you want to weigh in on that as well? Since I saw you nodding on...
Oh, sure. From a business perspective, I think if just to use an example, newspaper article comes out that questions a practice, you can guarantee it's not just going to be one regulator that is asking you about that practice. So it is absolutely more efficient from a business perspective to work collectively with the regulators to make sure there's a common understanding, to get the facts straight, et cetera. So yes.
Can I ask, practically speaking, like how does that work best? Like what would you like to see as industry? But I'd love to hear if there's civil society or NGOs in the room as well. What would you like to see being set up to facilitate that, to institutionalize that dialogue a little bit more?
So there are varying answers to the question. It depends on the issues. So we are seeing a multiplicity of different regulators touching on data right now. We've got the competition regulators, the privacy regulators, consumer protection, telecoms regulators, and so I think that as James was pointing out, some of the really positive working together of those regulators is very helpful because there are tensions. I mean, there are data protection tensions with the competition authorities. There's data protection tensions with the e-safety regulators. So for us to see them working together and then talking to us and engaging with us, and we are happy to do that because for us, ultimately, getting the facts out is important.
Thank you. So let me turn to the audience, see if we have a couple of questions. I see 2 questions here in the front row on my left. I'm just grabbing a mic and we'll be with you in 30 seconds. And I see a 3rd question in the back. Thank you. And a 4th here. I'm just keeping an eye on the time because we have a very active audience, which is great. We can start over here on the left. We have 3 hands up. on the third row. If you can just state your affiliation as well and your question. Thank you.
Hello, Carlo Rossi Chauvenet, Bocconi University, Italy. So I take what Mr. Gencarelli said and Mrs. Horvath said also about the collaboration between, not only between authorities, but between the authorities and the DPO in order to help company to be compliant. And so my question is, sandbox between different authorities and companies, would that be more accessible? Would that be more accessible to companies? Do we need a new law to state that, or can we follow the example of the ICO and other authorities, the Norwegian authorities, for example, that did that? Because I think that it is so important to install a collaboration and to understand what is the product like through an active collaboration before the enforcement is done. Thank you.
Thank you. Anyone wants to take it?
Well, I can start. I think that, and I'd like to talk more about the philosophy underpinning the sandbox rather than the sandbox itself. And that philosophy is the axiom that the best way to address a privacy risk is before it happens. It's less resource intensive for the organization. It doesn't impact upon their reputation. Less resource intensive for the regulator. And then as well, it avoids the harms to citizens from their privacy rights being compromised. So the sandbox is one new tool towards that, of pursuing a more proactive approach to engaging and avoiding those issues before they occur. And the sandbox is predicated on the idea of having that authentic and unguarded dialogue so that authorities can provide you advice, regulators can provide you advice based upon the fact scenario that you have provided. But I think others, I know the sandbox is a concept in many different organizations.
Sorry, I'm notoriously softly spoken. So yeah, I mean, that was our thinking in terms of sandbox. And through our sandbox process, what we're not giving is a carte blanche. What we're doing is engaging with the organizations. We're a whole economy regulator. We have, to produce services that are fit for purpose, from everything from the small family bakery and blacksmith, which is keeping its customer details, right the way through to the large merchant bank in the City of London and everything in between. And Sandbox, but also our wider advice services give us that opportunity. So we have the Sandbox, but we also do other things like supervision. So when the law enforcement community in the UK was looking at facial recognition technology, we worked with the two advanced forces there to supervise their deployments, to make sure that we understood what the processing was, how it was working, how the technology was being used, whether it was effective or not. And then we produced a commissioner's opinion that we produced for all of the police chiefs in the UK through Chiefs Council to set out our expectations for future deployment of the technology. And we've similarly done that for commercial applications of the technology. But because we have to keep abreast of everything that's happening across the economy in a very complicated and fast-moving space, that contact and engagement appropriately, and don't get me wrong, there are points at which the engagement becomes less fluffy and less open and helpful and moves more into what I think some people would view as enforcement. But we have to do that to make sure that we are appropriate in our responses to the risk and the potential for harm posed.
Thank you. I'm going to ask to move the mic to Bruno, and then we'll go back to a couple of questions in the audience.
As I'm a good commission official, I will answer to the bureaucratic question, which is, you don't need a change of the legislation to develop Sandbox, because all these examples that you have mentioned, UK, Norway, but also in other of our member states, even if they're not called Sandbox, they're doing through tech labs of Data Protection Authority, have all been developed within the current framework. that has also been useful to for other regulatory framework. I'm thinking, for instance, the current work on AI that very much builds, and there including through possible legislative regulatory instrument, very much builds on the use of sandbox. Last comment on this, from my side, it's all connected. You will never get anybody in your sandbox if there's no credible enforcement mechanism. Huh? You need an incentive, and enforcement is part, and credible enforcement is part of that incentive. So again, we're back to the spectrum concept of Miriam.
Thank you. Let's go back to the audience. We had a couple of questions there on the third row as well. Lady standing, and then the question in the back. We'll take both at the same time.
Thank you very much. I'm Irvet Tempelman. I'm from the Dutch industries, the wide range, the smaller ones and then larger ones and everything in between. I would like to say a praise for not the single focus that we heard this morning. I'm not want to be negative about this morning, but I was missing the wide range of enforcement tools that you address, and I'm really happy for it. What I would really like to see is indeed the cooperation and the collaboration and the learning approach that you are saying. What we see in the Netherlands, and I don't think we're the single ones, is that cooperation and collaboration is not really there. So how could we, well, whether we need legislation or not, but how could we really embed it in a way on a European level that cooperation and collaboration really takes place? And I'm not only talking about the DPAs, but I'm talking about the DPAs and the other regulators, because we see divergent opinions, not only between the DPAs, but also between the different regulators who have to look at the compliance of all the different regulations that they have in their portfolio. So that was like embedding that cooperation and collaboration in a real way.
Thank you so much. Let's go to the lady who is sitting right behind you as well. We'll take two questions.
Hi, Saibra Krasnik from the Goethe University in Frankfurt, Germany. My question is regarding to the possibility of companies taking advantage that here is a representative of the private sector, Apple. I would like to know what is exactly what you think about the possibility of implementing internal processes for the citizens, so the people from every part of the world, to complain directly to the companies, because we see that it is too much regulation. It is a process that it is complicated also for the public institutions to get all of this coordination among the different institutions. And the citizens have very few possibilities of actually claiming something before getting too high in the instances. And that would probably actually not only facilitate the work of the public instances and the European Commission and all of the local authorities, but also their own, when you don't want to get to those high processes where you probably will get costly fines and process to litigation too, you can probably think about that possibility, or what are you actually doing internally? Thank you.
I think that's geared to me. Yes, we actually have a facility. We have an email alias that you can complain directly to us, and our team will respond. It's privacy@apple.com. And, I think that is the best place to start with a company, is to write in, and there is someone that will respond. I can commit to that.
And so to the first question about how do we actually really embed that collaboration, I see a couple of hands up. Brent, you want to?
Sure. Well, I think mine's still working. Yeah. I think one of the questions in there was referring to the challenges associated with different legislations, and how do regulators, if they have legislative differences, collaborate. That's a really good question, and because the default assumption is that legislative differences make collaboration more difficult. And I'll tell you what we found is that often the legislative differences are advantages that allow you to have a more holistic outcome with respect to a joint investigation. And let me give you an example. Ashley Madison was a extreme dating site for those individuals wanting to have affairs, right? It had a breach, and we conducted a joint investigation, Canada, along with the Australian Privacy Commissioner and the US Federal Trade Commission. We all had different features of our legislation. The FTC had a consumer protection component. We had a consent through deception component. By addressing this jointly, we were able to arrive at an outcome that provided an even superior protection to individuals by leveraging the differences than we would have been able to achieve individually. So I guess that would be my answer to that, is that when you do see legislative differences, think how they can be leveraged rather than assume that they're obstacles and barriers.
From our experience, so very much agree with that. The other observation in terms of those differences I would make is they're often less than you think.
Oh, yeah.
In terms of what the differences are in terms of powers and interests. So firstly, I think ambition. So there's got to be ambition at the top of the office to support these kind of initiatives. Secondly, our experience has been what's worked well is where everyone's got a clear understanding of their role and responsibilities in the framework. And there are some frameworks out there to base this on. And thirdly, you've got to put resources in. It's to borrow a UK phrase, it's an invest to save activity. You've got to free up your resources, and the DRCF is a good example. Each of the 4 authorities have actually put staff into that construct and have put money into that construct in order to reap the benefits of better coordination, both for themselves but also those they regulate. And it's the same with some of the joint investigations, and I'm sure we will start to see joint teams, joint data analysis, joint technical analysis as we go forward, because that's what's necessary to sustain this and get the results that we want, in my view.
If I might add something to that, I think the DRCF is a great example of how you can institutionalize cooperation between different agencies. But I do agree with the person who asked the question, because the incentives to cooperate are not always there, right? It's complicated to cooperate. You have to sit down around the table with a bunch of other regulators with different perspectives, different rules, different legislation. And while I do agree in theory that we can leverage our competencies and build upon the addition of our competencies, it's not always easy. So I do feel that it is important that there is a clear directive from the law or from government that cooperation is necessary. And I feel that also from the point of view of regulators, an important aspect is that if there is no cooperation and if there are decisions going different directions, this ends up before the courts. And courts are not always best suited to solve complicated regulatory issues, especially when they involve legislation from consumer, antitrust, and personal data protection. So in Brazil, we have been working hard to create these cooperative arrangements, but it's not always easy because our counterparts in government do not always see issues the same way as we do. And as to the question about that was geared towards Apple on internal procedures for receiving complaints before companies, before bringing them to regulators, I feel that this is an important aspect of the responsive approach to regulation, since organizations themselves must be held accountable for solving problems before they get brought to the regulators and to courts. So I think it's a very good example of how accountability could look like in practice.
Thank you. We have time for one last question. See the gentleman sitting here on my right side. You will have had you step in today.
Thank you. Alan Rawls, Sidley Austin. Mr. Dipple-Johnstone mentioned collaboration on relief remedies. And I note in the Clearview AI decision of the ICO, there in the injunctive portion of the relief, the ICO drew on the remedy that was issued, I think, by a court in Illinois, and you expressly invoked that. Do you see more of that, and do the other regulators intend to have common relief elements? Really, I think incorporating, I believe in the case of Clearview AI, it was exactly the same provisions as in an injunction in the US. Is that something that you expect to see more of? And do you think that the respondents, the companies that are the targets of the investigations, do they like that, the overlap, or is it overkill?
Thank you. And just scanning the room, see if we have one final burning question. Yes, please. Just over here, lady with the gray.
Thank you. I don't want to make it a very political question, but I'm missing
At the end
out.
of the panel, you can.
Okay. So I'm missing out on the public sectors. Who is going to hold the public sector accountable? The governments, like the European Union. Okay, you produced GDPR, yes, but with the digitalization, like on a global aspect, we see that we are being influenced not only by like surveillance capitalists, like big companies, but also micro-influencers. So from a consumer's perspective, but also a citizen's perspective, like from coming to from Brexit to 2016 elections, like this is like a democratic right. Like, you know, I want to think individually. I want to be independent, and I'm being influenced constantly. And I think, like, you know, if we want engaged citizens, like we see that if we follow the headliners, like that's actually taking more attention from the citizens. And if we want to push, like, actually and enforce it, like we need to make that very clear and divide the consumer privacy right and also the democratic rights. Like, you know, the UK, I've been researching the rule of law. You have this nudging behavioral, social behavioral sciences, and you have this House of Common. You have those committees, and you publicly like accept that the government is actually nudging their own public. So I want to like ask from each of your perspective, how do you see this, and how can you actually give us a clear like guidance towards the future? How can I feel as a European citizen free enough from all these influences, and how can I protect my own rights, not only with the GDPR? And I know that all countries, they have their own constitutions, they have their own national laws and international laws, but I want to hear an honest answer from all of you. Thank you.
Do you maybe want to take the first question, and then we can come back to that second one and perhaps wrap up?
Sure. And I can probably only deal with one part of the first question because I don't know how it feels on the receiving end. I can probably make some guesses, but from the sort of regulatory perspective, yes, I think we will probably see more as we see more cooperation between regulators, both on topics but also internationally. It's kind of the elephant in the room. Why do joint investigations and then split out at the end at different timescales? Why not look at things a little bit more consistently? So I would expect to see more of these coming through. And on the second question, we apply the same cooperation techniques to our public sector and our government role as we do to our commercial role as well. So we have cooperation agreements and frameworks in place at election time with our election oversight bodies in the same way as we do cooperation with the digital regulators.
Thank you. And maybe as a wrap-up question, I'll let anyone react to those questions as well if you'd like to, but perhaps to wrap up as well, as we've heard that a lot of what we're looking towards is really that cooperation with authorities from different areas of laws. And obviously sitting in Brussels, we do see new legislation is coming into force and sort of creating the conditions for, or at least posing the questions about how to go about that collaboration. So I'm curious about your thoughts as well into how do we actually deal with this interplay between data protection, privacy, and consumer law, competition, and such.
I can try that one, and I think it'd be remiss, especially since this is a conference with the EDPS, to not mention that Giovanni Butarelli, about 7 years, saw this coming in terms of the collision between privacy, consumer protection, and competition. In fact, started the digital clearinghouse. And here we are, and it's front and center in terms of an issue. We've been talking about collaboration within the privacy sphere, but this is the future in terms of collaboration across regulatory spheres, consumer protection, privacy, and competition. I know in the Global Privacy Assembly under the Digital Consumer Working Group, we've been focusing on that very issue of trying to understand and appreciate the complements between privacy and competition while mitigating the tensions and advocating for greater collaboration. We see it in the DRCF, and we're seeing results. The DRCF in the UK, the sandbox. Singapore is now incorporating privacy considerations into their anti-trust laws. We've seen it in Germany with the antitrust case against Facebook, and we've seen it in South America, in Colombia, where their regulator has responsibility for privacy, consumer protection, and competition, and in resolving an issue, an antitrust issue in the banking industry that called for a remedy of the sharing of information. They made sure that they incorporated privacy considerations into that remedy to ensure that competition was not preserved at the expense of privacy. And I think that is the key, is that to establish these relationships and these partnerships across regulatory spheres so that the outcome is holistic and doesn't serve a consumer in one way while harming them in another.
Thank you. Bruno, and then we'll...
Oh, I can take it, sure. But let's hand it over to Bruno because he'll be speaking.
I don't want to give the impression that I'm trying to not answer to that question, although I'm not sure I fully understood it, but you will tell me. There were different levels. I think one has already been mentioned. Public authorities in Europe are subject to exactly the same rules. The GDPR applies to public authorities. We have a separate directive that applies to public authorities in the area of criminal law enforcement. We have case law and other rules, and also under the European Convention of Human Rights that apply to public authorities when they, for instance, process data in the area of national security, and also we have national laws in that area. So public authorities are accountable and hold accountable, and meaning if this is not the case, as the Commission, as we have shown, on an issue as important as the independence of data protection authority, we don't hesitate bringing those member states to court. The second dimension, I think, of your question is about the involvement, the consultations, the participation of citizens, of consumers. Well, in everything we do is open to public consultation. And this is one area amongst many others, but since I know it a bit better than from the original, since you mentioned the GDPR, from the original proposal of the GDPR that was subject to 2 public consultations, through the hundreds of meetings we had during the negotiation of the GDPR, to the implementation of the GDPR, when we refer to stakeholder consultation, that includes organization representing citizens, organization representing consumers, including in the so-called multi-stakeholder group, which is that we are systematically consulting on any issue relating to the implementation of the GDPR. But if you want another answer, I think the biggest success of citizens, of individuals in Europe, is that they are a main driver of enforcement. A lot of GDPR enforcement comes from individual actions, from consumers' action, either individually, but also through organizations that represent the individuals, through collective action. That's why one part also of your question concerns what we have done and what we're doing in terms of facilitating collective action in this area, like in many other areas. Also, for instance, protecting, and you have EU rules in that field, protecting a whistleblower within organizations. So we don't have time. To answer to your question, probably would need another conference, but this is certainly a dimension which is at the center of our policy. Otherwise, why would we even be talking about a fundamental right?
Thank you, Bruno. We just have a couple of minutes left, so I'm going to turn to Jane and Miriam for closing remarks. What would you want to leave the audience with after today's panel?
My microphone works. I think I've been talking about it throughout the session. I just think that there's a lot of efficiencies between regulators working with companies, getting in quickly. Companies have an obligation to reach out as well. If you've developed something unique that you think you've either got a neat privacy by design, it's really good to reach out to the regulators, engage with them, talk with them, discuss with them, or if there's some issue that has arisen, do the same. And then, of course, with the multiplicity of players, it's also very helpful because, you know, we privacy people might be saying, hey, there's a privacy issue with this other regulatory opinion or law or something. So it's very helpful for the regulators to be working together as well.
Thank you. And on the closing note, I think one of the issues that addresses both questions is the issue of independence of DPAs. Because in fact, if you have a regulator that needs to enforce legislation before the public sector and before the private sector, independence is a key issue. And in this sense, I'd like to close by sharing some great news we had yesterday from Brazil. I'm sure Bruno is excited as well because it facilitates international data transfers. But the Brazilian DPA was yesterday granted legal independence from the Presidency of the Republic. So this creates, I think, the best conditions for us to enforce regulation in a consistent, in a stable, and in a effective manner in Brazil. So thank you once more for the opportunity.
That's a very positive note on which to end the discussion. So sorry we went over time, but I hope it was interesting and insightful for everybody. So join me in thanking our panelists today. Thank you.